The U.S. Constitution was a coup d'etat. Good morning, good afternoon, or good evening from wherever you're watching or listening. My name is Caleb Glick. I'm a lawyer here in the great state of Texas with the Calhoun School of Law to bring you a lot of information that plenty of bad folks would rather you not have. Today, ladies and gentlemen, I'm going to show to you with historical fact and legally binding proof that the U.S. Constitution was never ratified legitimately nor adopted by the states legitimately. So first, we're going to go over the historical record, show to you the number of delegates that attended the Philadelphia Convention, what we know as the the Constitutional Convention, show how that violated the rules of the already existing government over the states, and how exactly the US Constitution violated the rules of that preceding government and thus not being a legitimately adopted, consented to form of government. So first, we need to outline exactly what this preceding government was. Yes, there was a government over the states before the U.S. Constitution existed. That preceding document is called the Articles of the Confederation. Now, the Articles were drafted up around 1777 and weren't fully adopted by all 13 of these states until about 1781. However, it provided a vague consensus, or to use its own terms, league of friendship between the states. It was somewhat the standard, the expectation, but it didn't become binding on all 13 of the states until about 1781. So I want to show you this document, I want to show you this government, and show you this last clause that brings into question the legitimacy of the U.S. Constitution. So here it is, the Articles of the Confederation. Article 1 says, "The style of this confederacy shall be the United States of America." And I do want to quickly show you Article 2 before we get down to the article that was violated with the Philadelphia Convention, just because Article 2 is so interesting and really shows exactly what the purpose of the Articles and the Confederation was, but also what the U.S. Constitution was supposed to be. It's also important to remember that the Philadelphia Convention was called to amend the Articles of the Confederation, not to completely replace it with the U.S. Constitution. So Article 2 to the Articles of the Confederation says, "Each state retains its sovereignty, freedom, and independence, and every power, jurisdiction, and right which is not by this Confederation expressly delegated to the United States in Congress assembled." So if it's not overtly declared, it's not a power given the Articles of the Confederation Congress. Okay, so now for the article that's being violated with the Philadelphia Convention. It is the last article, in the first paragraph of that last article. It says, "Every state shall abide by the determination of the United States in Congress assembled on all questions which by this Confederation are submitted to them. And the articles of this Confederation shall be inviolably observed by every state, and the Union shall be perpetual, nor shall any alteration at any time hereafter be made in any of them, unless such alterations be agreed to in a Congress of the United States, and be afterwards confirmed by the legislatures of every state." So when we're considering an amendment, let alone completely replacing the Articles of the Confederation, it has to be unanimously agreed to by every single state legislature. So now here comes the historical fact concern. For the Philadelphia Convention, which is called completely fair, completely legitimately, for the Philadelphia Convention, 70 delegates were called, 55 attended. Right there, you've already failed the unanimous agreement requirement prescribed in Article 13 for the Articles of the Confederation. It was Article 13, correct? Yes, Article 13. So you've already failed. Of the 55 who attended, only 39 voted to ratify the U.S. Constitution. Again, failing the unanimity requirement of Article 13 in the Articles of the Confederation. Well, Caleb, it came to be true that 9 of the 13 states voted to ratify the U.S. Constitution. That that satisfies the requirements in the US Constitution to amend or to install a new government? Sure, but it still fails to meet the requirements in the Articles of the Confederation. Thus, given the Articles were still the binding government at the time the US Constitution was being considered, any procedures, any amendments being suggested had to comply with the Articles of the Confederation. Now, does this mean that the US Constitution couldn't have been installed? No, it absolutely could have, if they had had it sent to every single state legislature, and every single state legislature voted to ratify the US Constitution, voted to replace the Articles of the Confederation. Or if these states, which, as you read throughout the Federalist Papers, which if you haven't gone, please go and read or go and listen to the Federalist Papers series we have on Rumble. I'll begin migrating that series onto YouTube. But as you read through the Federalist Papers, if all of these different states, those 9 states in particular, felt so threatened by the inadequacy of the Articles of Confederation, they could have done what the original 13 states did with the Crown. They could have seceded. They could have declared their independence. They could have gone their own way and then made a new convention, made a new government, but they didn't. Not a single state declared their independence from the Articles of the Confederation. None of them seceded from the Articles of the Confederation, even though they had every power to do so. And Alexander Hamilton in the Federalist Papers, specifically 85, openly admits that they are violating the rules and the terms of the Articles of the Confederation by not getting unanimous agreement among the delegates to the Philadelphia Convention, nor the 13 states. And he says, I answer in the next place that I should esteem it the extreme of imprudence to prolong the precarious state of our national affairs. So what is that? That's the typical, generic, tyrannical, authoritarian playbook. Fearmonger, fearmonger, fearmonger. Unprecedented times. If we don't do it this way, if we don't do what's necessary, we will get destroyed. We will be imprudent. We will put ourselves in jeopardy. So we have to break the rules. We have to go and violate these terms we agreed to in a firm league of friendship, to use the article's own words, and to expose the Union to the jeopardy of successive experiments in the chimerical pursuit of a perfect plan. I never expect to see a perfect work from imperfect men. The result of the deliberations of all collective bodies must necessarily be a compound, as well of the errors and prejudices as of the good sense and wisdom of the individuals of whom they are composed. The compacts, which are to embrace 13 distinct states in a common bond of amity and union, must as necessarily be a compromise of as many dissimilar interests and inclinations. How can perfection spring from such materials? It doesn't matter. The Articles of the Confederation require that. If you don't like it, declare independence from it, and then go and do whatever you wish with the U.S. Constitution. It appears to me susceptible of absolute demonstration that it will be far more easy to obtain subsequent than previous amendments to the Constitution. The moment an alteration is made in the present plan, it becomes to the purpose of adoption a new one, and must undergo a new decision of each state. To its complete establishment throughout the Union, it will therefore require the concurrence of 13 states. So he's openly acknowledging that yes, in fact, to make any amendments, let alone completely replace the agreement that's already been made, you have to have unanimous agreement between the states. So if the U.S. Constitution doesn't attain that, it then cannot be binding law, because it didn't obey the terms of the Articles of the Confederation, this binding government. If, on the contrary, the Constitution proposed should once be ratified by all the states as it stands, alterations in it may at any time be effected by 9 states. Here, then, the chances are as 13 to 9 in favor of subsequent amendment, rather than the original adoption of an entire system. He's openly, without hesitation, admitting Article 13 to the Articles of Confederation require unanimous agreement for amendments, let alone completely replacing the government. We know for a fact that 70 delegates from the states were called, only 55 attended. That's already failing Article 13. Of the 55, only 39 voted to ratify the U.S. Constitution. Again, failing unanimous agreement. When it was sent to the state legislatures, which it couldn't have been, pursuant to the Articles of the Confederation, even after it was sent to the state legislatures, only 9 out of 13 voted to ratify the U.S. Constitution, failing Article 13 to the Articles of the Confederation. So in short, if you want to make the argument, well, Caleb, it was necessary. Well, Caleb, the articles were insufficient. They didn't form a strong enough government. Fine. They could have done exactly what they did with the crown. Declare independence, secede relations, saying that this government is detrimental to the posterity of these citizens in these states, and go and form a new union under the U.S. Constitution. But if you, for any reason, try to justify violating agreed to terms in a binding contract, then you're advocating not for a government of laws, but a government of men. Men who come to your door and say, if you don't do things their way, you're going to die. If you don't break the rules just this time in these unprecedented days, you're going to die. If you, for any reason, justify violating terms of agreed to contracts, then you're already failing the entire purpose of the contract existing in the first place. There's no reason to have the contract at that point if unprecedented times can overrule the terms of that contract. So with the Articles of the Confederation, it requires unanimous agreement. They didn't get that with the delegates. They didn't get that with the states. Thereby, the U.S. Constitution cannot be ratified, cannot be implemented, cannot be legally declared as law. And it's because of the reasons that the Anti-Federalists, which is another series I have available on Rumble that I'll begin migrating onto YouTube, or will begin migrating onto YouTube. It's for the reasons that the Anti-Federalists thoroughly articulated in the Anti-Federalist Papers that the U.S. Constitution was not ratified legitimately. A quick tell as to why the U.S. Constitution, or how we can know for certain that the U.S. Constitution was implemented rather than ratified, or better imposed rather than ratified. The Philadelphia Convention was held under sworn secrecy. Does that sound like a government of the people, by the people, for the people? Does that sound like a government consented to? Does that sound like a government free and republican in nature? Not remotely. Again, can the U.S. Constitution, could it have been implemented legitimately? Absolutely. And it could have been done either by the states declaring independence from the Articles of the Confederation, or obeying the terms of the Articles of the Confederation, getting unanimous agreement between the delegates, and then unanimous agreement between the state legislatures. But since that didn't happen, since the Articles was still a binding contract on those states, on the 13 states, the U.S. Constitution, its consideration and its implementation had to conform with the rules of the Articles of the Confederation. If it didn't, which in fact it didn't, it's not binding law, it's not a legitimate government, and it's not one that was formed under true, honest, or consented to pretenses. If you think the U.S. Constitution should be binding law, should be a legitimate government, and you wish to just disregard what the Anti-Federalists predicted in 1787 before the U.S. Constitution was ever implemented, then obey the terms of the Articles of Confederation and let the people decide. Uphold and actually practice a free government, republican principle. If you wish to neglect the almost prophetic predictions of the Anti-Federalists in 1787 regarding the inevitable ends of the U.S. Constitution, obey the terms of the Articles of the Confederation and have it ratified. But until then, it was never ratified, and it was never legally, honestly, consented to, agreed to, and thus non-binding law, and the government formed under it, non-just, non-admitted or recognized for exercising powers. So if you have any questions about this topic, maybe you think I'm totally off my rocker, or maybe there's a legal topic you'd like me to cover in a future lecture, go ahead and post those down in the comments, because the entire purpose of the Calhoun School of Law is to equip you with the necessary skills and information to combat any sort of lawfare that will be waged against you, your loved ones, or your hard-earned property. So please, if you have any questions at all, go ahead and post them down in the comments. Excellent. So my name is Caleb Glick. I'm a lawyer here in the great state of Texas with the Calhoun School of Law to bring you a lot of information that plenty of bad folks would rather you not have. I hope you enjoyed this lecture, and if not, while you're down in the comments, go ahead and let me know how I can do better so I can best serve that purpose of helping you. Hope y'all have a wonderful day, and until I see y'all in the next lecture for the next topic, I bid you all farewell.